Good evening. Welcome back to Money Mondays, a series on legal rights during the COVID-19 pandemic. Next slide. Good evening. Welcome back to Money Mondays. We hope you had an opportunity to view one of our prior discussions on how to quickly access stimulus payments and circuit breakers. As an update, we'd like to remind everyone that the unhoused do qualify for an economic impact payment, even if they do not normally file taxes or may not have an address. The IRS is currently working to develop a portal where individuals who are unhoused can provide banking information so that they can receive their economic impact payment via direct deposit instead of by mail. Next slide. As an update to our presentation on small businesses and COVID, we'd like to let you know that there are financial assistance programs available for churches and religious institutions. There will be a faith-based webinar series, session 3 of a series, taking place this Thursday, May 14th at 6 p.m. The topic will be presented by Ms. Lisa Potts, who is also a member of the St. Louis Financial Empowerment Coalition. The details and information can be found on Facebook at BCR Wellness Champions Facebook page, and the Zoom link is included below. Next slide, please. At Legal Services of Eastern Missouri, we are proud to partner with the St. Louis Regional Financial Empowerment Coalition to bring you this series of information. The St. Louis Regional Financial Empowerment Coalition's mission is to promote equitable opportunities for financial health to build wealth and economic prosperity. Next slide. At Legal Services, Action, Justice, Hope is our motto, and our mission is to advance justice through legal representation across 21 counties in the state of Missouri. Next slide. Tonight we have with us Attorney Terry Lawson of our consumer program, who will speak with us about student loans and COVID-19 relief. I'll now turn it over to Terry. Thank you.
Thank you, Tasha. I appreciate the introduction. And today our topic for what was formerly Money Monday presentations and now will be just legal services presenting additional information for consumers and others. This topic covers student loan basics as well as COVID-19 and how COVID-19 interrelates with student loans. My name again is Terry Lawson. I'm a consumer program attorney at Legal Services. There we go. We had just an error there for a second. Today we're going to go over 3 major categories of information. The types of student loans that various people have. This is a surprisingly confusing topic for a lot of folks in terms of what type of loan they have and how would they know more about the loans. We're going to break out the basic types of federal loans, the 3 major types that you would see, which covers about 90% of all student loans throughout the country. We're also going to discuss certain issues related to student loans, their status, so that you start to get familiar with what a term means as it relates to a student loan you may have, and then the types of payment plans that exist for the federal student loan program. Lastly, the last portion of the program will be the specific student loan reliefs offered in the CARES Act. The CARES Act was recently passed by Congress, rushed through as a way to assist everyone in this terrible crisis we're living through with the coronavirus issues. And in March, late March, this CARES Act included a variety of features that would be helpful to student loan borrowers. We're going to talk about what those major issues would be and the major benefits will be that CARES Act might provide. First off, by way of background, the total student loan debt in the United States is enormous. There's approximately about $1.560 trillion worth of student loan debt. Almost 1.6 trillion as of 2019 third quarter. So probably now we're very close to 1.6. And the rate of growth is astounding. It's very difficult to wrap your head around how fast the loan problem is growing. $9.2 million an hour, roughly. So by the time we're completely finished today, another almost $10 million of student loans would have aggregated in the economy. That is enormous. And as we say, because we have such a huge crisis in the student loan area, the understanding how to deal with student loans is becoming more and more important to consumers generally, and even to all the lawyers that are throughout the country. Student loan law has become somewhat of a topic, and I'm one of the lawyers in Missouri that are becoming more familiar with student loan problems. Legal Services offers certain student loan assistance through our consumer program. And if we can assist you at some point, you're welcome to give us a call and find out if we might be of assistance. So let's go through now. How do you really get control of your student loans? What do you need to do? Many times this seems like an overwhelming thing for people and they're not sure where to begin. So first, know your loans, know the type, the amount, the status of your loan. That's some of the stuff that we'll be teaching today, the terminology that you need to understand, just so you can converse about these loans to the servicers that you might be calling. Also know your payment plan and be sure you choose the plan that matches you. Lastly, know what kind of relief you need to ask for if things change. Everyone reaches some kind of financial crisis. This COVID-19 crisis we're in now has caused a crisis writ large across the whole economy. So the CARES Act addresses some of those financial problems for student loans and many other things. But regardless of the CARES Act, the student loan landscape has tons of different nuances that can help you if you fall on hard times financially. And we will address some of that today as well. So federal loans, as I mentioned earlier, they make up 90% of the loan volume. When I say the word federal loan, I'm talking about the what used to be called Stafford loans. Many people that received loans in the past heard that term, or the Forward Direct Loan Program. Basically, any loan that has the Department of Ed's logo on it, if the Department of Education, which I'll refer to here as ED today, or ED. If ED or ED is involved, then probably that is a federal loan. The United States government offers support through federal loans and considers it part of the financial aid package that students can apply for. Private loans are basically the same as any signature loan you might have heard of in any other scenario. Just like you could go and get a small loan from a bank or a small loan from a place down on the corner, if there's such a thing as a small cash loan there. These are simply promissory notes that you're really bound to the terms of the underwriting of that loan. In other words, if they have really particularly onerous terms or interest rates, the terms in that document control, and there's not a whole lot of flexibility to that. So those are, in my opinion, the worst kind of loans a student borrower should try to get. The federal loan programs, while stifling, while there are issues with them, there are also regulations that require certain fair treatment to borrowers. So there's definitely a lot more you can do to adjust things with federal loans than with private loans. Particularly if you're on the lower end of the economic spectrum and you have to borrow a considerable amount, avoid private loans if you can, unless you are 100% sure of the terms and conditions and that it's extremely fair to you. And I say that because of this difference between the regulations of federal loans and private loans. Lastly, we should talk briefly about state loans. In some states, these are possible. The state of Missouri really doesn't do much in the way of offering state loans. They're really rare here. Other states have larger programs where the state itself might have revenue that they would use for student loans. Effectively, then, what we really see is that we have two types of loans for most people, federal or private. So I'll be totally focused on federal and private today in the presentation. So let's figure out how do we know what we have, right? In federal loans, we have one type called the FFEL loan. The FFEL or FEL loan program started way back when the Stafford programs began, all loans from 1993 before, and they phased out really in the aughts, the 2000s, completely out by 2010. So if you have an older loan, you might see FFEL on that, and that is an older and less flexible style of loan. The direct loan program, the William D. Ford direct loan program, covers most loans from about 2005 forward, and basically any federal loan from 2010 forward would have been a direct loan from the government. The older loans, FFEL loans, were originally made by a bank or other institution, and the government only backed those loans as a guarantor. So the actual lender was a different lender for FFEL loans. And that's going to matter today in the presentation later, because the assistance provided by the CARES Act actually doesn't apply to the commercial loans that are still held by an entity other than the Department of Education. So putting that in a simpler way, if you have an old FFEL loan, but the United States government doesn't hold that loan, the CARES Act will not assist with that. So one of the things you might want to do in arranging your loans is trying to make sure that the loans you have remain with the federal government if you can. That's one of the things that will help you get better information and better quality from your servicing usually. Plus loans are a type of loan that many people are confused by. These are generally parent loans or graduate student loans. And what plus loans basically were built to do is to provide a supplemental loan for a student if the school was so expensive that even after giving all available aid to the student, there was still a leftover need by the student. So generally, these are only going to exist whenever you have a very expensive school or there's a graduate school program that was expensive. If it's a graduate school loan, a student could take out a plus loan. Otherwise, the parent alone is the borrower. There's not a situation where a plus loan is actually a student loan that's for an undergraduate. I have people come to me and say, well, I went to college, I have a plus loan. I say, no, you don't have a plus loan. It would mean your parent has a plus loan. The parent is the borrower on those. And no federal loan is going to be co-signed. If you have a loan with two borrowers, that's probably a private loan that was co-signed by two people. It's not a federal loan in almost any case. Only the very old loans of the federal government allowed two people to be the promissory party on those. Lastly, we have Perkins loans, and these are very small loans, generally under $5,000, oftentimes under $2,000, and those loans were basically paid out and made by the schools where the party visited. So if there was an exceptional need, once again, it was someone that really needed additional assistance, then the school had a certain block of money that it could offer as a Perkins loan to those borrowers. And those Perkins loans have slightly different rules also. Remember, these were given by the school, not directly from the Department of Education. So these loans are treated slightly differently, but were made back in the FFEL period and also in the direct loan period later. This is totally confusing to most people. By this time, most consumers that come to me say, well, how on earth am I going to figure out what student loans do I have? I don't have my paperwork. I took this loan out years and years ago. Nobody gave me any papers. How am I supposed to know what I did? So we're going to walk through the easiest way to understand what loans you have. The keys to knowing your student loan are really the first one here, studentaid.gov. I used to say go to the NSLDS, the National Student Loan Data System. But now the direct website that is basically a new and improved version of the data in the NSLDS reports will be found on this studentaid.gov website. The government is working hard. It will take some time, but they're working hard to revise the Department of Education website. and it's much more thorough than it used to be about providing information. We'll talk a little about that later. You also can look at the credit reports that you may have from annualcreditreport.com or any one of the big three credit reporting agencies, Equifax, Experian, and TransUnion. You can go to annualcreditreport.com and request your reports online for free once per year. You can always do that. Now, during this COVID crisis, it's also true that the three agencies will give you a free report every week. So there's actually now a special program where you can obtain these every single week if you wanted to for free. This is what the studentaid.gov website would look like. It does require an FSA ID to log in. Lots of folks don't know their FSA ID, so that would be Federal Student Aid ID. If you don't know it, you need to go to fsaid.ed.gov to manage or create your ID. When you went to school to begin with and first did a financial aid application, you were given an ID of some kind. Now, with the renovations to the systems, I found that I used to be able to look up my information one way. When I went back to do it again, it said, oh, you don't have an ID. So even I had to go back in when I had a student loan for law school and go ahead and basically manage and recreate my account. This isn't unusual, but it does take a day or two sometimes to get this straightened out. I would urge you to make sure that your FSA ID is always working and that you check it just like your credit report so that you know what's going on with your loans. Once you have logged in, you can go into here, the in repayment portion, to learn about options you have in default, repayment plans, etc. This is the portion that after you've taken loans, this is the section you'd want to go to. Whereas these other three sections really apply toward people that are just going to school, trying to figure out how to finance school. Annualcreditreport.com, as I mentioned, is an online site where you can get your credit reports. There is a paper form that you can sometimes locate. We have those in my office as well. And you can either send a letter, you can send a form, or you can go online and try to answer the challenge questions they have to prove that you are in fact you. And if you can do that, you get it online. Now, many of my clients have trouble with that online application. I would suggest if you do, you might go ahead and just do the letter instead. But I wanted to point out when I went to the web page, it now says offering free weekly online reports through April 2021. So for free, you can get these. You don't have to pay any other agency, and you can double check what's going on with your credit report. Now, once you've obtained the reports, first you look at the National Student Loan Data System. That's Department of Ed. If it is on the National Student Loan Data System, that loan is surely a federal loan. Okay, so if you go into the Federal Student Aid website and you look at the loans there, then obviously if those match up, you're in good shape. But if it's not on that NSLDS, you don't see a loan, or there are no loans, but somebody's telling you have a loan, then I would check the credit report, okay? Because next, the credit report would have loans that are reported by private loans as well as by federal loans. Most people that give a large loan want to be paid back, and one of the easiest ways they can do that is put it on a report, put a derogatory mark, and hope that the consumer calls to try to clear it up. So we find that private loans are frequently added to the credit report when you can't find those in the studentaid.gov site. So if you see that it is on the credit report and the NSLDS, that's normal. That would mean it's a federal loan. It's on the credit report and not with the federal government's webpage, then probably a private loan. But if you can't find it on either one, very strong indication it's a glitch of some massive proportion, possibly a scam, some major issue, because both of these types of reports are well over 95% accurate. I would say in the case of the federal student loans, they're 99% accurate. It's very unusual to have a loan listed there that you actually didn't take out. So if you cannot find either your loans in either location, but someone continues to try to collect you, I would really, really be cautious about that if you can't verify that they're legitimate. If you still can't figure this section out on your own, you're still not sure how to get your student loan information, you could call 1-800 for Fed Aid, or you can go online to studentloanborrowerassistance.org, and I've given you the website right here, and it walks you through step by step how to obtain this information. So if you forget the slide deck, you forget my information, but you can go to this site, you can also walk through and figure out your loans. So we've covered the first portion of our outline. We've talked about the types of loans that exist. And now we're going to go to the student loan issues that are specific to usually federal loans, since that is the 90% of all loans. And as again, last, we'll cover the CARES Act information. Let's talk about what kind of repayment plans the Department of Ed likes to give people, or what are available, what plans are available to you. The big differentiator is standard type plans and income dependent repayment plans. So let's unpack that a little. Standard repayment, like a car payment or a mortgage, these are payments that are calculated based on the balance of the loan. How much money did you borrow, and how many years will you have to pay it back at what interest rate? So that's very easy to calculate that math and determine that each payment would be an equal number for so many years. The typical standard repayment is a 10-year repayment cycle. You can extend it to longer periods for a lower amount, but usually it would be the same interest rate. So if you stretch out a loan longer, it's going to make your interest go up, even though it makes your payment go down. So what you really want to do is do the fastest payment you can if it's based on a standard repayment system. In other words, if you can afford a 10-year, you should probably keep it because you'll pay so much more interest otherwise. Now, many people simply can't afford their standard repayment, and that's why we now have income dependent repayments. There are several income dependent repayment plans, and they are not tied to what you owe, they're tied to how much you make, your income. So if you make less than 150% of the poverty line for your state, your official payment under one of these is generally zero. That's mind-boggling to some folks, but let me repeat it because it bears repeating. If you have an income crunch, you're employed but barely making it, or you're unemployed, or you're on public assistance, and for your family size, the amount of income you have coming in is less than 150% of poverty for the state of Missouri, then you could apply for an IDR plan and your official payment amount should be zero, which is amazing, but true. Many, many people don't realize they could actually be in an official plan, but not have to pay, or pay very little per month. If you make more, you'll pay more. But if your income drops, you'll also have your payment drop. So this works out not just for the poor or the working poor, but also any middle class folks. Most of the time, the income dependent repayment plan is probably a cheaper payment than it would be under standard. So again, standard repayment plans, 10 years is normal. Graduated could be adjusting the amount you pay. The payment gets larger on the assumption you might make more money. Or you can have an extended fixed payment up to 25 years or a graduated payment up to 25 years. The default rule is always the 10-year payment. So if you're in some other type of plan and that plan ends because of a paperwork problem or you didn't recertify, etc., Department of Education is going to automatically put you back to a standard 10-year payment. If you were on a low-priced payment because it was income-based and suddenly now the parties that collect from you say, oh, you now owe so much per month, much, much more, hundreds per month. The odds are what happened is that instead of using the income payment, they went ahead and switched it to a standard payment, which only looks at the balance of the loan and not what you make. So that's a sign that something went wrong and you went back to standard repayment. And for many people, if they can't afford that, it really causes a lot of problems. So next we talk about the types of income-dependent repayment plans that exist, the income-based plans. This is kind of an alphabet soup of letters. And so I encourage you to go to the Federal Student Aid website and look at these plans a little more carefully. Pay as you earn is a very good one. 10% of your discretionary income over that poverty line would be the payment amount, and it would be forgiven after 20 years of making that payment. So you could make just 10% of not your total income, but your discretionary income. In other words, if you were a very low earner, it may be zero, and you just stay on that zero payment for 20 years. For others, they might have a payment of some amount per month. Income-based repayment is similar to pay as you earn, but a slightly different plan, and certain terms and conditions apply. It is also can be 10% of your discretionary income for 20 years or 15% for 25 years, depending on whether or not you are a new borrower after July of 2014. So that means if you had recent student loans but did not have older loans, then you may qualify for this IBR for new borrowers. Also, there's an income contingent repayment plan, which is one that we usually don't recommend to many because the payment is 20% of your discretionary income. Now, also recently, after Pay As You Earn came out, the government also passed one other one called Revised Pay As You Earn in 2015. And that particular repayment plan is similar to Pay As You Earn, but it allows older loans to be considered for it. And it also allows a 20-year limit for undergrad, 25 years for graduate loans. There's one little wrinkle to this, and the repay loans, if you have that payment plan, those can include your spouse's income in calculating what amount your payment should be. There is a way to separate out the separate incomes if you file separately, if you properly file your taxes, which could ultimately reduce your payment in the other types of payment plans, but repay would not allow that. So again, it pays to look through all the plans and determine what's best for you. Now there is a new calculator on the website for Department of Ed that allows you to simulate your goal and then determine what works best in your situation. Studentaid.gov loan simulator does that. You can say, I want to pay my loans off as quick as possible. I want to make my payment as low as possible, and so forth. And then it will help you and describe for you the different things you might do for that particular loan type, or based on your loan types and which plan might work. You can see here I'm struggling with payments, or I want to find a repayment strategy. These are all options on the loan simulator page. So next we have the special repayment plan that I wanted to mention. It's not really an income dependent plan on its own, but it covers quite a few people. The Public Service Loan Forgiveness Program is a plan that allows people in certain payment plans to have their loan forgiven, not in 20 years or even 25, but in 10 years. And to qualify for public service loan forgiveness, you have to work in public service, such as doctors at a nonprofit hospital, a nurse, any other nonprofit worker, generally with certain little exceptions, government entities, people like firemen, police, etc. Also teachers who work in education, and many other nonprofit programs can qualify. So there are quite a few wage earners that can do this if they have the right loan, the right payment plan, and the right kind of employer. It goes beyond the scope of today's presentation whether or not this would fit for everyone. But if you think you may have the right kind of employment, this should really be investigated, because many people discover they could have done this and finished their loan payments in 10 years, but they didn't do it quickly enough, and so they've delayed that benefit. It's a good idea to check into this if you think your employment might qualify. So what if I can't pay my loan? What if I'm not paying anything? I just know I have one and nothing's happening. Well, likely then your loan is falling into one of 5 statuses. Either you're in a deferment, a forbearance, you're delinquent, defaulted, or in discharge. I'm going to go through these loan statuses. So basically everything not repayment, because you're not paying, but maybe one of these other statuses apply. You need to understand what status you are to determine what things you need to do next. So it's important that we go through and understand the terms. A deferment is really a loan payment delay. It's basically stopping the loan from moving forward. And it's usually going to be for some very unusual circumstance, special hardships that might exist. The one everybody usually is familiar with if they've gone to college is I'm still in school, therefore my loan is deferred. Many people have heard that. Oh, I have a deferment, I'm still in school. My deferment usually ends 6 months after school ends for the most part. But there's also graduate fellowship, rehab training. If you're in military service, you're a parent plus borrower, unemployment, economic hardships, even as a cancer, currently in cancer treatment. These are all special hardships that allow for deferment. They don't all result in a no interest deferment, but many are, the interest is either waived or paused while you're in deferment. And it'll depend a little on the loan and the program that applies. Forbearance is similar, but not identical. It's really just a pause on your loans as well, but usually the interest accumulates in a forbearance. You're not going to see generally a deferment type interest being waived. Most of the time your interest will continue to run. So even if you're not paying your loan, but you're in a forbearance, the loan gets bigger and bigger because the interest continues to pile on top. And that's a surprise to a lot of people. I have people come to me that say, I know I'm fine, I'm in a forbearance, I shouldn't have any problem. But then they're stunned by how high their loan has gotten, and that's because the interest keeps piling on. Now, there are several kinds of forbearances. Some are discretionary. That means the servicer can choose to give it to you or not. Others are mandatory, that if certain things exist in your situation, they have to give it to you. There are too many to discuss in this presentation, the types of forbearances, but keep in mind that it's not always the best fix. I see a lot of people that say, oh, my loans are fine, I'm in forbearance. It's really not the best way to handle it. For one thing, you don't really have a path to forgiveness as if you were in an income-driven plan. If you're in an income plan, then you know that so many years out, if I do everything right, my loan's forgiven. Forbearance does nothing to assist you with getting toward forgiveness, with moving along toward that goal. It doesn't discharge the loan ever either. So you're not going to end up with a discharge of that loan. That loan will just sit there and get bigger. The one time a certain kind of forbearance might be useful to you is the COVID-19 relief under the CARES Act. And that's the end of this presentation. We'll discuss that there is a special administrative forbearance that the CARES Act provides for. That means the government, through paperwork, essentially, is putting some loans on pause as a result of the CARES Act. It's not someone asking for that forbearance, but because of the law, they automatically are using a certain kind of forbearance to pause the loans. And we'll talk about those impacts here shortly. Now, if you've not paid and you're not in forbearance and you're not in deferment, then you are either delinquent if you haven't paid, or you're in default on the loan. Under the rules of student loans, 270 days or less late on a payment makes you delinquent. Delinquent just simply means late. Nothing's happened yet, but you're late. Default is the biggie. If you're in default, it's more than 270 days late, 9 months late on your loan. So you haven't made a payment when you were in active payment status for 9 months or more. Now, every loan that has not been paid on 9 months or longer isn't automatically in default. I have seen cases where servicers forget to put them in default or just don't put them in default. And I think one of the reasons they're doing that is because the higher these default numbers get, the more alarmed everyone seems to get. And I think there's some motivation for certain servicers to not switch loans to default. I can't be positive I'm right, But I see people that go 2 or 3 years with no payment and not be in forbearance, and somehow they're not defaulted. So I can't tell you it's automatic, though the rules say if the person hasn't paid, it should be default. And so they're not always following that rule, but understand that that's probably what's going to happen. That default comes with a lot of consequences we'll discuss in the next slide. There's one exception to this 270-day limit, and that's Perkins loans. Those little loans that the schools can give out, usually I said less than $5,000, and the school pays it directly. If you're late even 1 day on a Perkins loan, you're in default on that loan. And so my advice usually is if you have multiple loans and your Perkins payment is tiny, but your other loans are bigger, pay your Perkins. Make sure it stays current, because that's the one that'll fall into default the quickest. And then you have some time, up to 9 months, to figure out what you're going to do with the rest of your loans. But no need to default that Perkins if you understand that it's in default on day one. Since it's usually a tiny loan, it's also going to be the very smallest payment almost always. So applying money to that makes the most sense if you can't cover all the loans, but you could cover at least one. Consequences of default are huge. I said, and I would go ahead and cover these with you. It really costs the consumer really big bucks to go into default. And one famous quote I've always liked is, it is expensive to be poor, which means it seems so often the people that are hardest hit in the economy have the worst penalties and the worst interest rates and so forth. And this really is true in student loan land. If you are late on your payments, the government has set up a structure to make sure you're punished for that in such a way that you will not want to ignore the student loans anymore. First, they will capitalize the interest and the fees. That means they take the interest that's accrued, and instead of your principal being, let's say, $10,000, if you had $1,800 more interest, that gets added to the principal. Now principal becomes $11,800. It makes the base amount bigger, and then interest gets charged on that bigger amount. Now that's a snowball that you absolutely don't want, but it automatically requires the interest and the fees gets capitalized if you get defaulted. The default is also listed on a credit report, so it's going to affect your credit score, your ability to get certain loans, things of that nature. A lawsuit is possible. The government could sue you because you're in default now, but that's not likely because the Department of Education doesn't even need to sue you to collect money. I'll talk about the remedies a default allows here in a moment. The collection tools the Department of Ed has are different from most other creditors that you might find. If you make a loan from a bank, let's say, that bank can't just all of a sudden grab money out of your wages. They can't grab money out of your tax return unless they sue you, win, get the judgment, and then execute on that judgment. That's when they could garnish you. The US government doesn't have to do that. Some of these remedies are very important. Once you're defaulted, they can just use administrative means, not judicial, but through paperwork, send something to your employer and say, this person's in default. You need to start garnishing the wage. No judgment required. They can, with United States Treasury and the IRS, tell the Treasury, hey, if this person should have a refund, send some of that or all of that refund to us to pay for the defaulted loan. This happens all the time. We have consumers come in tax season that had a default, went ahead and filed their taxes. Maybe they were expecting an earned income credit. If you're in default and you file, that whole refund can be taken to cover the defaulted loan. So you wouldn't want to have a default when you file your taxes. You want to correct those defaults so that you can get the refund you deserve. Social Security payments, which most people believe can't be touched. Believe it or not, some of your Social Security payments, certain ones, can be taken if you're defaulted on a student loan. It can't be all of it, but a certain portion of it. Federal employees can get offset of their wages. You can't get a federal job if you're in default. You can't get new financial aid from the government if you're in default. And you don't get new deferments while you're in default. So a ton of different remedies, this is just a portion of them, happen when you're in default on a federal loan. Let's talk a bit about discharges, because we did cover forbearances, deferments, and delinquency and default. What is a discharge of a student loan? A discharge means to get rid of the loan legally. It actually terminates the whole loan legally. Sometimes these would have tax consequences, other times not. It depends on whether or not the income or the discharge is considered a taxable income. Sometimes the IRS will consider a debt forgiven to be just like if you made the same amount of money, because if you don't have to pay that debt anymore, effectively your income goes up, in a manner of speaking. It's a debt not owed. So certain types of discharges for federal loans are taxable right now. We don't know if this is going to change, and not many people have gone out the 20 years necessary on the forgiveness of loans to see if the IDR plans would be taxable. But the PSLF is supposed to be not taxable at all. So in 10 years' time, PSLF winners or grantees would end up having a discharge of their loan with no tax effect. One good type of discharge for many is the total and permanent disability discharge. If you have a total and permanent disability rating from Social Security, or you're a veteran who is rated as unemployable, totally disabled, then you can apply through Department of Ed for a discharge of the total loan you have. Many people don't understand that if they are on disability currently and receiving disability, if that's a total rating, they may be able to completely wipe out the loan. I see people all the time come into the offices of legal services that are disabled, but there's some payment they're supposed to make on their student loan, and they've never been told by anyone about the TPD discharge. So if that might be you, or you know someone who is disabled but still is making a student loan payment, they absolutely should check on that and find out if this discharge applies. There are school-related discharges of student loans as well. If a school closes within 180 days of the time the party was there, that may make it an eligible discharge. If the school basically makes some kind of lie, falsely certifies that the party could have benefited when they couldn't, then that could be another type of discharge. You see some of these are things like ID theft, or they forged loans. They've enrolled a student that couldn't meet the employment requirements of the program. An example there would be, let's imagine a license that the school program is supposed to give you needs a high school diploma or a GED, but the party getting into the school has no high school diploma or GED. That would be a false certification. So if there's something like that where you find out the program you're in you couldn't possibly have qualified for when they let you in, then this false certification discharge could work. Also, sometimes schools will not pay back a certain amount of the loan money that was extra, what people call disbursements, because normally they would pay off the tuition that's owed, and then some additional amount goes back to the student of that loan amount. There are times when a school just keeps it all. And in those instances, if they did that wrongly, then that might make a person eligible for discharges. Bankruptcy discharge is another method to discharge a student loan. Now, many people hear, you can't discharge a student loan. That's absolutely false legally. It is true that it's very difficult in some cases to discharge a loan, but not every student loan is impossible to discharge. There's a standard in bankruptcy that basically can allow for discharges in certain cases. Most people don't ever try to discharge the loans in bankruptcy. And so therefore, most people don't get a discharge. But if there is a good reason and there's an undue hardship to that consumer, the bankruptcy judge can grant a discharge in certain scenarios. And it does happen, it's just rare. So if you have to file bankruptcy anyway, if there's a financial situation where bankruptcy might be right for you, you should absolutely look at whether or not student loans could be discharged in your bankruptcy, and talk very seriously with your bankruptcy attorney about that. because many will say, oh, they're difficult, but you really have to press more for information about what makes them difficult, why would I not fit, and see if perhaps your situation could make your student loans dischargeable in a bankruptcy. So now we've covered the types of loans that exist, the statuses of loans, the various payment plans that can come up in student loans. Now we're going to talk finally about the CARES Act itself and the strange little things that it's allowed. Many of them are good, but you needed some of this background information to even understand, what applies in the CARES Act to certain kinds of loans. So let's go ahead and walk through those now. The CARES Act was passed, signed March 27th, 2020. This is the official name of the law. In my packet online, if you'd like to download it, I have the whole act. It's 800 and something pages, originally printed by Congress. But if you wanted to dig through it, you're welcome to do that. A couple of the sections cover student loans. 3513 and 3508 are the student loan provisions. This does provide protections for borrowers, mainly in the types of situations where borrowers have to make payments, and also certain actions that the Department of Ed will take to collect from borrowers. That's the two areas that the CARES Act touches upon. Not all student loans are covered by the CARES Act. The direct loans I talked about, the newer loans, they're covered. And if the FFEL loan, which I said was an older loan usually, if those are owned by the Department of Education, in other words, or the US government has the loan and not the bank that might have originally done it or some private creditor, then that loan would be covered. Many older loans that are stuck in this FFEL status will not be covered by CARES Act. Those older loans might not fit. Anything I would say from about 2005 forward, there's a good chance that it's a direct loan and likely eligible. So the commercially held FFELs, not covered. Perkins loans, remember the small loan that the schools can give out? Those are not covered. And of course, the private loans I talked about that are not related to Department of Ed at all are not covered by the CARES Act. The CARES Act does suspend payments in certain scenarios. It basically says that the payments, all payments would be suspended if it's an automated payment program on a federal student loan that is covered. So these non-defaulted direct loans and the FFEL loans currently owned by the Department of Ed, for this period of time, March 13, which is a little before the act went into place, up to September 30th, the auto debit payments are suspended during that administrative forbearance. Now, you remember I said something about forbearances generally have interest running while you're in forbearance. This is an administrative forbearance, meaning a paperwork forbearance where the government automatically did it. And the CARES Act forbearance allows for a suspension of the interest as well. So it is a little different from most others in that the interest will be paused if your payment is suspended. So it also said in the CARES Act that the auto debited payments that were processed but that should have been suspended can be refunded to the borrower. But what that means, can be refunded, is what you might expect. It can be, but it's not automatic. The borrower has to request from the servicer of the loan, the company that's paying, or actually that the payments go through. You have to request from them that money comes back. So if you think you should have gotten a suspension, money was taken, but you'd like to get that money back, you have to make that request to get the amounts that was auto debited from an account. That means you have to take an affirmative step. You have to call, ask, I see that payments came out after March 13th. Those were auto debited from my account. I think my loan should have been suspended. And so can I get that money back? The answer should be yes, you can. The interest waiver I mentioned before. Unlike other types of forbearances, the CARES Act is providing that the interest will not accrue on covered loans. So instead of it running more and more interest for that period, March to September, no interest on those loans. So that's excellent. That means that even if it's not an auto debit, potentially you're going to see less interest over this period of time. Okay. It has to be the suspended payment loans that are covered by this. So it would be one where a loan payment actually did stop. And there's a question about, well, what if they took payments but didn't actually stop the payment in time? It really would be the money should get refunded and that interest should come off, both. You should get the refund of the payment plus no more interest accruing during that period. Collection of loans is also being suspended. Involuntary collection is all of that bad stuff I mentioned about defaults. So now that you know what a default can do, they can do a administrative wage garnishment or a tax offset. Those things should be suspended. The law said that they shall suspend all involuntary collection until September 30th. So no wage garnishments, no offsets, no Social Security offsets, nothing should occur. It even has a catch-all that says any other involuntary collection. So anything else they might do to try to collect can't happen until after September 30th. That's good news for people that are in default, because that means none of these things should start up during this period to September 30th, 2020. Everyone should pay close attention whether or not the government extends this period beyond September 30th as well, because the inability of Ed to do these garnishments or offsets will cause, I think, will cause kind of a backlog of loans to be collected. And I think they'll want to immediately restart, if they can, the day after the loan, the suspension period ends. The credit reporting for the CARES Act also touches upon the loans being reported to credit agencies. If the loan has a payment that was suspended, that loan payment was paused, then it shouldn't be reported that that loan was late or unpaid. It's supposed to be treated as if the borrower had made the regularly scheduled payment. Now, any reporting has to be accurate, but it's unclear the exact wording that would need to be on there to be an accurate report. There wasn't truly a payment made, but the law requires that it should be treated as if it was made. So you'll have to carefully look at the credit report to see if that was done if you're one of the borrowers where your payments were suspended. Most importantly is it shouldn't be a negative late report to the agencies. And you should make sure that you check your credit report regularly for these kinds of errors if you have this kind of loan. If a party is in school during the CARES Act period of time, that March to September, and they have to withdraw as a result of the coronavirus crisis, the Department of Ed must cancel that borrower's direct loan that is associated with the payment period when they withdrew. So understand that what that means is if a student is in school and they're getting a direct loan from the government and they have to leave school because of the crisis, it's supposed to allow that entire loan to get canceled. But how to prove the withdrawal is as a result of the crisis, and how to know for sure when you leave school that this will occur, that is unclear. It's important that you check with the Financial Student Aid Office of the school you're going to. And if you're currently in crisis because of the coronavirus situation, it may be possible to cancel the entire loan when you leave school if you have to withdraw mid-semester. But I would not jump headlong into that withdrawal until you are sure from the Financial Aid Office and the Department of Ed that your loan would qualify for this cancellation. If it does, however, that's a powerful remedy for people who were forced out of school because of something that went wrong. Borrower notifications are going to occur as a result of the CARES Act. What that means is either by email, by text message, by letter, there should be notifications going out to borrowers. You should have already received those in April if yours is one of the suspended loans. If you think that your loan should have qualified for payment suspension, you didn't get a notice, you might check that the contact information you've given to your servicers is accurate. You can go on to that studentaid.gov website and make sure the contact information listed there in your profile is right so that you will get the information that you need. Now, as of August 1st, 2020, the servicing agencies will also start sending out 6 different notices to inform the borrowers when normal payments will resume and to let them know that payment options exist. So imagine we should see 6 separate notices. Hey, it's August 1st, September 30th, you're going to resume payments again. And then there'll be another one and another all the way through to 6. So if you're being suspended, you should absolutely not be surprised by September 30th if these 6 notices all go out. Don't be surprised if you receive many, many different notices. Now, the weird part of the CARES Act to me is that these suspended payments and collections are supposed to count for the forgiveness plans and loan rehabilitation plans. When we say count, what we mean is it's going to count as a qualifying payment. For income-dependent plans, pay-as-you-earn, repay, IBR, etc., people are in those plans with the goal of having 20 years of payments or 25 years, and then the loan can be forgiven. But what happens here with this counting a payment that didn't happen? Well, CARES Act says these will count if your payments are suspended. But I would be very careful that you check with the servicer to determine when is the end date of my loan, because 20 years out from now, no one's going to remember to check all the way back to this period of time. It'd be much better to look at it now and make sure you understand, are these payments counting and how many more payments would I need to qualify for the forgiveness program I'm in? For public service loan forgiveness being only 10 years, it's especially important because March to September is almost half a year of payments. So it makes a pretty big difference whether or not those months are counted or not counted in the program. If you have defaulted on a student loan, you can also do something called loan rehabilitation. And that requires 9 payments in that program. So if you're in the middle of a loan rehab in default, trying to get yourself out of default, these months during the suspension are supposed to count toward the rehabilitation. We also don't know how that counting will be done. But again, the party has to work with the servicer, the collector doing that rehabilitation, and make sure they know how many months of the 9 are covered by suspended payments. If you're hearing none of them count, then that should be a problem because CARES Act should require it. There are also some other, unknowns here. Like we said, we don't quite know how the forgiveness will work way down the road with public service, with the income dependent plans. And what happens if a borrower is below full-time status at work, therefore they wouldn't normally be in a qualifying employment because of COVID-19? We don't know if the Department of Ed is going to say, well, since you lost your job or you were less than full-time, we did say these would count, but you weren't fully employed, so now they don't count. There has been no clear wording from Department of Ed yet on this. If you are someone that this might apply to and you've lost full-time employment, but you normally would be in the public service loan forgiveness program, you should be checking with the servicer about that. We also don't know if someone finishes rehabilitation during the suspension, are they stuck in rehab, or will they actually get to switch out of default as normally occurs? This is another question mark because we don't quite know what this count for rehab really means. And so at the end of 9 months, if we're not to September 30th yet, it doesn't seem clear that people will automatically come out of rehab. That's something else that hasn't been clearly worked out. The good news is these CARES Act remedies provide for some people to get a suspended payment with no interest charged on the loans, and it should allow them to still count that time toward ultimate forgiveness of the loans. And that's all good. It also allows, again, for someone that has to leave school, potentially that loan might be canceled, and that's very good. But you can go to the Department of Education's website for the coronavirus announcements for any of the changes to this. I suspect that the Department of Ed will need to make sure that they continue to adapt this program and explain some of these questions that I've brought up. So you can visit this site if you think that one of these situations of suspension or other might occur to you, might apply to you. You should be checking this site out fairly regularly. Lastly, I wanted to mention that all the materials, again, are available for download. You can go to this QR code if you like, snap a picture of that with your phone if it reads QR codes, and it'll jump to the folder where all of my materials are stored. Or you can type in or click on this shortened website. It is password protected, but it's a very simple password, student loans, no spaces. And you can jump right in and get a copy of the slide deck or get some materials from the Student Loan Borrowers Assistance Project or R1 sheet from Legal Services. All of those are available for you. That concludes for now the presentation. I don't know if we have time for questions, but Tasha, I believe, is back.
Yes, thank you for that advice, Mr. Lawson. We will now take a few questions from the viewers. We do have a couple. Tammy Gibson asks, can a borrower enter into rehabilitation during this period?
I don't see anything in the CARES Act that prohibits the entering of rehabilitation, and I haven't heard anyone be prevented from entering into rehabilitation. If you've been told you cannot enter, that would be unusual to me. So if you're in default and you need rehabilitation or consolidation of your loan, that should still be possible. There's no reason under the CARES Act that would prevent it.
Okay, thank you. Terry, so our next question. Can older loans qualify for IBR or income-based repayment plan after 2014 if the borrower refinances or consolidates their loans right
now? Now, repeat the question regarding, is it FFEL loans that we're talking about?
Yes, I believe so. The older loans that are pre-2014.
Yeah, so that's the bit confusing, but an older loan might be a direct loan. If you're saying I know I have FFEL loan, can that be in the IBR? There are certain programs that FFEL can qualify for, but it's extremely limited. The broad scope of all the income dependent plans, you would have to consolidate the FFEL into direct loans, because the direct loans are the ones that have the most programs available. For example, if your FFEL loan is commercially held and not held by Department of Ed, CARES Act doesn't apply. Well, another thing you can't do is public service loan forgiveness. So you would want to convert them to direct in order to be eligible for any program that you read says direct loans only. Those must be converted.
Okay, great. I have another question. If I defer my student loan payments, will all the deferred payments become due at one time, or will they be added into my loan?
Deferred, use the word deferred there. You may mean forbearance or deferment, a pause of some kind. None of the programs require that all the deferred payments would be owed all at once. What's going to always happen is that the loan gets larger because of the interest that adds on, if it is one that interest accrues, and then the payment structure is restructured so that you end up making a regular payment, not a payment of all of those suspended payments at once. You know, no student loan federal loans require it to be, I'm paying all those at one time.
Thank you. Terry, another viewer asks, is there anything a borrower can do to stop their Social Security from being garnished because of student loan debt? And where can they find additional information?
If you are already in default, then you have to remove the default in order to remove the collection action trigger, okay? There is a slim number of cases where you can appeal a collection action, such as taking some Social Security money. But what really tends to happen with those is appeals get denied frequently. So what you would want to do is come out of default in order to remove the reason to have that garnishment or that offset happen. And you can do that either through consolidation or rehabilitation. To get more information, you should be able to do two things. One is contact the servicer of your loans, which you should learn from the reports that I described on NSLDS or credit report. Or two, you can come to an aid organization that does student loan work. If you qualify, for example, for our representation, we can help with that, and other agencies on occasion help with it as well. A borrower shouldn't necessarily have to hire an attorney to do the work. It's not required by any means, but if you need assistance, there are folks that can help with it.
Excellent. Thank you so much for that, Mr. Lawson. I don't see that we have any additional questions or comments. Thank you, Mr. Lawson, for your time this evening. Thank you to all of our viewers for joining us for another Money Monday. Today's session and recordings from our prior events are saved on our Facebook page. Please like and follow us on Facebook for additional legal information and updates. Also, don't forget to join us next Monday at 6:30 for our Facebook session titled Contracts and Lease Issues for Businesses During COVID-19. Our speaker will discuss how small businesses and nonprofits can address COVID-19 issues impacting contracts and leases. Come learn more about common clauses used in contracts and leases that can benefit businesses during economic hardships. See you next Monday.